It's pretty remarkable if you think about it, that the client would choose a clinic of law students versus like a Williams and Connolly or a Covington, right?
Yeah.
Is this like pro bono?
So two things. Like one is, yes, like we offer our services, free of charge, right?
Yeah.
The
students aren't making aren't billing hours for this.
You could see the car that I drove in on. It was not a Lamborghini. So
this is Admissible. I'm Natalie Blazer, Dean of Admissions at UVA Law. I'm so excited for today's episode, not only because it's something I get questions about all the time from prospective students, but also because I think the topic we're discussing today is very relevant to the times that we're living in. My guest today is Xiao Wang, director of the Supreme Court Litigation Clinic at UVA Law. He has led appeals and argued cases before the U.S. Supreme Court, the federal courts of appeals, and other federal courts and agencies. In addition, he organizes the Onbanc Institute and supervises the National Appellate Clinic Network, which was recognized as a finalist for Bloomberg Law's Law School Innovation Program. Professor Wang previously worked as a litigator at Williams & Connolly and Wilkinson Steckloff, where he led investigations or litigation on behalf of Mars, Under Armour, and the National Football League. Professor Wang writes about federal courts, constitutional law, and law and religion. His work has appeared in the Michigan Law Review, Vanderbilt Law Review, and Columbia Law Review Forum, and his popular writing has appeared in Bloomberg, the Chicago Tribune, and the Los Angeles Times. Prior to joining the law school, Professor Wang taught at Northwestern Pritzker School of Law as a clinical assistant professor and director of the Appellate Advocacy Center, where he supervised the Supreme Court and federal appellate clinics. Professor Wang clerked for Judge Karen N. Moore of the U.S. Court of Appeals for the Sixth Circuit and Judge Lucy H. Coe of the U.S. District Court for the Northern District of California, although I believe she's now on the Ninth Circuit. Professor Wang earned his BA in economics and master's in public policy from the University of Virginia, where he was a Jefferson Scholar. He earned his JD from Yale Law School, where he was a Truman Scholar. Before law school, Professor Wang worked as a consultant at McKinsey & Co. What a bio. Welcome to the show, Professor Wang.
Hey, thanks so much for inviting me to be here. I'm really looking forward to it.
I am too. So as a little icebreaker, I love asking people who were here for a time as students in Charlottesville and then went away and then came back, because that's what I did. But did you have any favorite spots as a student and either the same spots now as a professor or different?
Yeah. There are some spots that have stayed constant favorites. So when I was a student here, the Bodos on the corner actually opened after a long-awaited construction timeline. And so
opened for the first time?
The Bodos on the corner, I think it opened in 2007 when I was an undergrad.
Wow. So that's when I was in law school.
Yeah.
I don't even think I realized that it was new at that point. That's cool.
Yeah. So that the herb cream cheese and everything bagel has always been a steadfast constant for me. I would say one thing that's changed is when I was a student here for maybe a special once a year, maybe once every 2-year treat, I would go to 10 sushi or C&O. And luckily, the law school pays me well enough that I can go there a little bit more regularly. Not that much more regularly, but a little bit more. And they're obviously sort of standouts in the Charlottesville dining scene.
For sure. So speaking of your time here at UVA, even though you didn't go here for law school, you are a double who.
Yes.
Because you got your undergrad and your master's. So how did you decide to come to UVA?
It was sort of on a little bit on a lark. One of my friends from high school, his brother had come to UVA, and I grew up in Cincinnati, Ohio. And one of my friends from high school, his brother had gone to UVA, and I'd been like, his brother was this sort of 3-sport star and head of the class. And when you're growing up in Ohio, not everyone even goes out of state.
For sure.
So I asked him, I was like, well, so why'd you decide to go out of state and why'd you decide to choose UVA and all that? And he said, well, it turns out I got this really great scholarship, the Jefferson Scholarship. And he told me all about it, and it sounded like this amazing package. It truly is an amazing package. And I remember thinking, well, we were going to go on an East Coast college visit swing with my parents, and we decided to stop in Charlottesville. we literally took the scenic route and like stopped by and just saw the mountains and everything. And I sort of loved it. And I remember going to the sort of the admissions committee sort of open house. And I asked them about the Jefferson Scholarship because I was like, wow, this is a sweet deal, such a great deal. It's such a beautiful campus. How could you say no? And they were like, well, yeah, no one gets that. So just try to like apply and get in, and you'll have a great time here. And so I sent in my application and applied to a couple other schools as well. And I think each round of the Jefferson Scholarship, it's sort of this multi-round process. Each round, I don't know how it happened, but I would just make it to the next round and make it to the next round. And I ended up getting it. It's incredibly fortunate, really privileged, very blessed to get it. And I mean, that makes the decision really easy, I think, because UVA is such an amazing school. The people here are just incredibly nice and kind and wonderful. The other students, the faculty at the undergrad are just fantastic. And it just made it a really easy decision to come here. And I've never regretted it.
I love that story. Nobody gets that. It just goes to show you have to try.
I know.
Don't let people get you down.
Exactly. No, so I'm very happy to report. I don't even remember who the person from the admissions office was, but I definitely my parents and I laugh about that sometimes.
I love it. So I think I read somewhere that it was during your time here in undergrad that you were maybe taking some law-related courses. I think even maybe from one of our current law school faculty.
Yeah.
So tell me how that worked, and was that when sort of your interest in maybe going to law school sparked?
Yeah. I think my interest, my mom says my interest started when I was sort of conscripted into doing mock trial as a sixth grader. And she was like, you become so passionate about this. And I think my parents were like, my parents are both in the medical field, and they're like, he's never this passionate about Petri dishes. And so I was like, yeah, I mean, fair. I think, but sort of more seriously at UVA, I got to know Micah Schwartzman quite a bit. And he sort of had been a mentor for me when I was an undergrad. He had helped me navigate the Jefferson Scholarship process. He helped me navigate the Truman Scholarship process and some other postgraduate scholarships. And I got to know him, and I thought, wow, what a fascinating sort of career that he's had at that point. And I was a sort of super dork in the time, and I'd read a little bit or tried to read a little bit of his law review work and academic scholarship. I was so fascinated. Yeah. So, my last year in undergrad, I said, well, I hope I can go to law school someday and maybe someday go to UVA. But in the meantime, do you mind if I just sit in on your constitutional law seminar? And I thought it was just amazing to sort of see him and to also see the students really wrestle with these tough questions that the Supreme Court was wrestling with. And it just brought a level of rigor and a level of discussion that I didn't see in some of my other classes. And so I think that was the time where I thought, well, I really do want to go to law school at some point. But I don't know if this is something that I should be telling, but on a podcast. But so on a lark, I decided to sort of take the LSAT without studying my senior year, and I did not do very well on it. So I had to take a few years off to work for a few years and concentrate a little bit on studying for the LSAT and doing a lot better on it, and that opened a lot of doors.
I'm glad you shared that, though, because I always say the LSAT is not a diagnostic, right? Like you need to study for it.
For sure.
And although I have had guests on here who are like, I just took it and then, great. I was like,
I don't believe that.
Good for you.
Maybe.
Yeah. So you went on, so you got your master's in public policy here.
Yeah.
And then, like you said, you worked for, was it a couple years?
Yeah, I worked for a couple years.
Yep. Okay. And then ultimately you went to Yale Law School.
Yes.
How was that experience?
I think Yale's really quite a different place than UVA in some ways. I mean, it took me a while to find my footing there. There were a couple other folks also that had gone to UVA undergrad that were there, and that was really nice to have that community. In some ways, sort of navigating Yale was just a different place at first. But I ended up sort of finding a really good group of friends, a really good group of professors. I tried to spend none of the winters in New Haven or the springs in New Haven. And I really look back fondly, ultimately, on my law school experience. I think, I have sort of lifelong friends and lifelong mentorships there.
I think I saw you were in the Supreme Court litigation clinic at Yale Law School. So was that kind of, I'm just curious, were you sort of, that's where your interests were going, like this sort of appellate level litigation and the real clinical work?
Yeah, I had this is one of the mentors I got to meet was my first year I got to take a class with Linda Greenhouse, who was then sort of the New York Times Supreme Court reporter.
Yeah.
And
that's so cool.
Yeah, I know she does some short courses here every few years, but it was just interesting to hear her talk about sort of being at the Supreme Court, listening to argument, distilling it, and then teaching it to students, and all in sort of the course of like a week and a half.
Yeah.
And I really enjoyed the seminar, and she encouraged me to apply for the Supreme Court clinic, and I ended up sort of getting in. It was this. I think there's a sort of a application process. I can't really remember, and ended up getting in. And yeah, that sort of. It sort of took this idea of like, hey, here's the cases you read, and now you're going to work on one that might end up setting the law.
Yeah.
So yeah, I thought that was really fun and interesting and unique to do in law school. Sort of also intimidating at first.
I cannot even imagine. When you were in law school, I'm curious, because Yale is sort of known for like, if you want to get into academia, I think a lot of people think about Yale and Harvard.
Yeah.
So, like, were you surrounded by people who, like, wanted to be law professors? Is that what you wanted to do? Or what was that like?
Oh, yeah. I mean, I think this podcast is trotting out all my embarrassments of, like, my bombing the LSAT. And in law school, actually, it's weird, like, there are a ton of people that want, especially at Yale, that they want to be law professors one day. And I think I had entertained that. My dad is a professor of medicine, and, I've always sort of been interested a little bit in research. But it's sort of embarrassing. I think that I think UVA has this too. The Virginia Law Review has a similar process, but at Yale, you can write like a student note, which is sort of like this, essentially this short law review piece that a student writes, a form of student scholarship. And you're encouraged to sort of write your student notes and submit it and have them review it, and sort of the best notes will ever get chosen and published in the Yale Law Journal or the Virginia Law Review or whatever law school you're going to. And I mean, this is so embarrassing, is that, when you send in a student note at Yale, they'll always send you back they try to give you some feedback and try to send you back a memo. And usually the memo has sort of like 3 boxes that they can put your student note in. One is like, hey, this is amazing and we're going to publish it, and we just need you to make a couple small changes and work with us to do that. And the second box is, there's some idea here, but you really need to make all these changes and revise and maybe come resubmit.
Yeah.
And then the third box is like, no, just don't come back. Please don't come back. And I would say that they tell you up front, they're like, maybe like 5% of pieces get in that first box that are accepted. And then, 90% or 92% are in that second box of like, we think there's something here and try to keep on improving and refining. They're like, very rare. They tell you this at the start. They're like, very rarely will we ever put you in box 3. Which is like, please don't come back. like do not pass go again. And I remember I submitted sort of 2 notes for consideration, and both of them got box 3.
Oh my God.
and it was just like,
wow.
I remember seeing that and being like, well, probably just like too dumb to be a law professor. Probably should give up this idea, this thing, and just be sort of a big law lawyer or something. So it did not work out as well when I was in law school. I'm happy to say it's worked out a little bit better since, but yeah, there were definitely a lot of people that were interested in it, and I just honestly didn't know if I was cut out for it.
I love that story. It's very real, and I think it helps people who, first of all, when I welcomed our 1Ls on Friday, I said, while you are here in law school, like, try out for things, go for things. Yeah. You will fail sometimes, but like, you have to try. And that story is just such a great example of like, what if you had just decided, like, I guess I'm not going to have it? It's just, I mean, you can't take those things to heart. You have to keep trying. So I love that story.
Yeah. I mean, I think one thing that was helpful, I had a professor in law school, and I had gone up to her. She was a real mentor to me. I was her RA. I was her TA. Got this amazing, fantastic record, like a Rhodes Scholar, Yale Law School, and everything, and this incredible CV. And I talked to her about some of these struggles, and I was pretty candid about it. And she said something that was really helpful for me to think about. And she was like, the CV that you see on the website or the resume you see for your professors or for these big law partners or whatever, those are the greatest hits of their lives. And they never talk about any of their greatest misses. And sometimes you learn the most from your greatest misses. And I think that helped a lot because I think that all of us have things that, we wish had panned out differently, but we learn a lot from when they don't work out.
I love that advice. I'm going to remember that. It's sort of like what people say about social media.
Yeah, exactly.
You see people's highlight reel.
Yeah, exactly.
Not their, random day of just doing nothing.
Yeah.
So I love that. So you ultimately did get a couple of clerkships.
Yes.
How did that work? Did you do them back to back?
I did.
Okay.
Yeah.
Tell us a little bit about your clerkship experience. Like, what was your favorite part? Was it challenging?
Yeah, I think my favorite part is that you sort of get a front row view of how arguments get made and sort of what works and what doesn't work. And usually you wouldn't get that. And usually you wouldn't be able to sort of peer inside the head of a judge. I mean, there's so many times now when I'm in court and arguing that I'm like, oh, I wish I could understand what the judge is thinking. And I could, but as a clerk, you actually do get to see that. And
so cool.
That's a sort of a skill that as a litigator, I just always go back to of saying, well, when I was a law clerk, my judge would think about these couple of things. Like, how do I think about that and reverse engineer that when it comes to working with my clients?
That's so cool. And then from there, you went to your law practice, right? As an appellate litigator.
I worked at Williams and Connolly first for several years, and you're sort of thrown in, and it's a firm that does a lot of different work, trial work, appellate work. And I wasn't you're not really assigned a group, but it's a little bit based on, hey, like if you show an interest in this stuff, if we lose a trial, there's usually going to be an appeal. So if you want to be on the appellate team, have at it and stuff. So it was a lot of sort of trying to seek out those opportunities and develop some of my skills at the law firm.
When I was at my law firm, I don't know if you're just being humble or what, but I remember our appellate group, that was like the all-stars. It was like, when you guys mess up at the trial level, they're going to take it from here. I remember a associate who I was very close with. We did a lot of pro bono cases together. He was in our appellate group, and I was like in like a trial group. And I just, remember he was like always writing briefs. He was always, our work was very different is my point. So for listeners who may not know, can you explain just like what an appellate, if someone's in an appellate group versus a trial group, like what's the day-to-day difference?
Yeah, I think the day-to-day difference is in the trial. In trial, you're trying to find facts, sort of shape narratives, and interview witnesses, figure out what your experts have to say, and sort of build this thing called a record, build a factual record. And that takes a ton of work. And especially if you're working with a big company, they have a ton of documents you have to sift through, right? And sometimes that can be a little bit monotonous. And I think there's sort of like a different form of, I suppose, monotony at the appellate level. Because at the appellate level, you're not supposed to build the record anymore. The record's sort of set. You're not supposed to find new facts.
Yep.
But in some ways, it's monotonous in the sense that you're trying to sort of craft these legal arguments. And, for instance, for one case that the clinic has worked on, one of our legal arguments depended a lot on sort of what 17th century British common law had to say. And so, I don't know if it's more interesting, less interesting, more monotonous or less, but it takes sort of a certain type of grit and perseverance to just sift through, what old bailiwick Story Fishburne had to say in the Court of Common Pleas and figure out, how that fits into your legal theory. So Yeah, I think that's sort of the difference between trial and appellate practice. I think in some ways there's certainly commonalities, like you want to understand how the law applies to the facts, but there are differences in the day-to-day for sure.
It's good for listeners to know there's going to be some level of monotony in
Yeah.
any area of your law practice, but also a lot of really exciting, like interesting things. So you did go from there, I believe, to Northwestern Law.
Yeah.
How did that, were you like, okay, I've really liked my time practicing, but I'm really ready to get into academia? Or how did that decision play out for you?
This is one thing where COVID actually sort of was a little bit of a silver lining. I know it feels so long ago, but one of the great things about COVID is it gave a lot of folks, especially in law practice, sort of a breather. If you were going at 100 miles an hour, you couldn't do in-person depositions. You couldn't do certain meetings anymore. And so the pace slowed down a lot at my law firm. And it was one where I had been thinking about a few different ideas, scholarship ideas. I mean, I think, recovered and licked my wounds from law school. And I thought, well, why don't I try my hand again? I'll write some short pieces and, I'll send them out to these law reviews, and especially their online supplements. Maybe this is also embarrassing, but I sent it to a dozen online supplements, this first piece. And it was one by one, they'd be like, no. And I was like, well, this is just replaying my trauma. And then I think one day, California Law Review, so the law review for Berkeley Law School, which is sort of very well-regarded law review, reached out and were like, we love this piece and we'd love to publish it. And I think it would be really, really fitting, and we'll sort of dedicate the resources to make it better. And, we're sure you have other offers. Listener, I did not. And I was like, we're sure you have other offers, so take your time. And it must have been one of those where, immediately I responded, probably, as they were, getting their cup of coffee from in California. And I was like, I accept. And so I think that was, and then I think once you sort of write one piece and you go through the editorial process, you sort of figure out a little bit how your own style works and how that style works with what other law reviews are looking for. So my next piece got published by Michigan. And so once I think you start publishing a little bit more, I started looking a little bit more into teaching and teaching jobs. And this opportunity at Northwestern came up.
Yeah, that's so fascinating to me because I did read just the title, some of the law review articles that you've had published. And I'm like, these all, to me, sound super interesting, the topics. I was actually curious if you're writing anything now.
Yeah.
I imagine you have to kind of keep going.
Yeah, sort of. I mean, I think I've been really fortunate that I have a number of incredibly bright students that work as my RAs. And, there'll be a figment of an idea that I have, and I ask them to look at something, and they'll come up with this incredibly detailed perspective, and that really informs me. So yeah, I have a few things that I'm working on right now. They're in sort of different stages of development. They're sort of in the areas that I have traditionally studied, so law and religion, sort of judicial organization, and we'll see where they get placed.
Yeah, that's awesome. So while you were at Northwestern, just tell me quickly, because I really want to dive into the UVA experience. I read that you created some sort of, and I mentioned in your bio, a network.
Yeah.
Basically, my understanding of it is a database for clinics to use. So can you explain that?
Yeah. And this is sort of a lot of the idea, the credit for the idea goes to Scott Ballinger, who's also on our faculty, and another very close friend of mine who's at NYU, Daniel Harawa. And basically both of them said, if you're working in an appellate clinic, if you're directing an appellate clinic, you end up seeing similar issues, and you sort of see that other clinics have similar sort of viewpoints or issues. Because a lot of clinics work on cases like habeas cases, criminal defense cases, plaintiff side civil cases. And you'll see a lot of overlap in terms of the types of issues, the type of cases, the type of plaintiffs that get represented by appellate clinics. And so Daniel and Scott both sort of independently told me, hey, it'd be great if we had a listserv and a briefs database, because every fall I feel like we reinvent the wheel with our students about how do you write a brief that presents a habeas question, or how do you write a brief that presents a prison conditions and confinement question. And I guess this is sort of where my value comes in. I said, well, we can do all that. If people start sending me the briefs, I can sort of, I have a very, very, very rudimentary understanding of how to code and put things in sort of a database form that's accessible. And so I said, maybe we can do that, and I can put that together, and that can actually be a database that people can search and use, and students can look at, so they can know that they're not starting from scratch. And so, we started with a couple schools. I think now we're up to like 24, and we've got 300 or 400 briefs, maybe more than that. And I think it's been people have told me it's been very helpful because, instead of, again, starting from scratch in the fall, they'll already have this template ready to go. And I think when you're an appellate litigator, if you have the template ready to go, that just gives you more time to sort of devote to some of the more difficult, challenging issues.
Sure. Yeah. So are you using that still in your clinic today?
Oh, yeah, for sure.
Awesome.
For sure.
Yeah.
I also don't want to start from scratch when we write briefs. So definitely I'll encourage my students to look and see if there's if other clinics have briefed similar issues. And if they don't find it, I'll try to find it too, just because it's just such a time saver.
Yeah. What is the Onbanc Institute? Maybe first explain what Onbanc means if people don't know.
Totally. So across the country, there's, I think, 12 to 13. It depends on how you count one of the circuits, but there's 12 to 13 sort of federal courts of appeals, and they hear appeals from these trial courts, which is where cases start. And they're sort of the intermediate layer between the trial court and the Supreme Court. And usually when you bring an appeal in those courts, your appeal is heard by this panel of 3 judges. And they end up voting, and because there's 3 judges, they always come up with a decision. It's like 2-1 or 3-0 or what have you. And after they come up with a decision, if you're not a big fan of that decision, you can do something called seek Onbanc review. And what that means is that the court itself, the appeals court itself, might have 15 or 18 judges. And when you seek Onbanc review, you say, look, I think these 3 judges that heard my first appeal didn't get it right. I want it to be heard by 15, the big 15-judge court. Sometimes folks will choose that route, and other times they'll choose to just go straight to the Supreme Court.
Yeah.
Either way, en banc courts end up, when the court decides to take up a case and hear it en banc, all the judges in that court, it's usually a pretty big deal. And often it's sort of a preview of what might come up in the Supreme Court going forward. Because if 15 sort of judges on the appellate court say, this is an important enough issue we want to take up, the Supreme Court might sort of be like, well, this is an important issue.
Because to get 15 judges to come together, you would think that this is going to be an issue that they're like, okay, we want to talk about this. Okay, cool.
Yeah, and I think one of the reasons I wanted to do it is because when you get a case that's before the Supreme Court, like a lot of people want to help you prepare for that argument. There are institutes and programs and other professors. And when you end up, in fact, arguing for the Supreme Court, usually you've had a couple of different practice runs. But it's not like that on the en banc side. Like, basically, we're the only people in the country that will sort of reach out and say, do you want to come here for a moot, and we'll help you. And people have said, well, literally, this will be my first and only practice.
Yeah.
And I think that's a really good public service to have and to offer. And it gives us a sense from the Supreme Court clinic side to say, well, hey, maybe we're not working on this case en banc, we're not representing the party, but now we know what the issue is, and we can track this issue. We can sort of help navigate it as it maybe pops up elsewhere and might show up in front of the Supreme Court.
So basically, you become aware of a case that's going to be heard en banc, and you reach out to them, and you say, hey, if you, the lawyers, want to come moot, like a full dress rehearsal, for people who don't really understand what mooting is, like full dress rehearsal in front of your clinic, to prepare them. Because like you said, typically you only do that before a Supreme Court argument. But as we've said, en banc is like nearly as important because of the issues at hand. Do the students get to like play kind of the other side?
Yeah, all the students get to attend the moots.
Yeah.
And one or two of the students will usually sort of stand in for the other side because I think what's helpful for the advocate is not just to sort of rehearse your own arguments, but usually how appellate arguments are is like one side goes up and then the other side goes up and then the first side gets to do a rebuttal.
Yeah.
And I've been in moots where I go up and I don't hear the other side, and then they just tell you, like, now's your time to do a rebuttal. And like, that's not super helpful. Because usually in the rebuttal, you want to talk about what was said and what was asked for your opponent and opposing counsel. So usually we'll have sort of a student stand in for the other side. And that's always a little fun. I mean, I think, we have students who are really interested in certain topics. Like we've had a moot about voting rights and sometimes the clinic wouldn't be necessarily involved in that at the Supreme Court stage, but they get to basically represent the other side in a voting rights case in front of their professors, in front of practitioners in a moot.
Okay, now I want to get to our time at UVA.
Okay.
So you were at Northwestern for a few years.
Yes.
And then you returned to UVA, I believe, in 2023.
Yes.
Was that kind of just always in your head, like you wanted to come back? Or how did that come together?
I think there were two different sort of warring sides on it. I loved my time at UVA, but I remember when I was at UVA just thinking, I'm not going to be a townie one day. I'm not going to be a townie like these people that love UVA and just stick around. That's not going to be me. But then the other part of me said, well, I loved and have really gotten to know folks like Micah Schwartzman really well. And Scott Ballinger has been a mentor of mine. And it'd be really, really amazing to be able to work with these folks every day. So I think I saw this opening come up and a few people reached out to me and encouraged me to apply. I applied and I didn't know if I would get very far. But I think the side of me that was like, look, I really love this place, and I don't know why I have this irrational worry about being a townie. And now I think I can say it on the other side. Like, I enjoy being a townie, and the summer months that the students aren't here is actually great.
I know.
There's never any traffic, and I can actually go to all the places and restaurants and plays that I want to see. So I would say the side of me that sort of always really loved this place and the people here won out, and I'm really glad it did.
Well, and I mean, again, similar to my experience, we went away. We did stuff. We did big city stuff. We saw the world.
Yeah,
to come back and it's a great place. For those who don't know, Micah Schwartzman, who Professor Wang mentioned earlier, he's also a UVA alum, teaches at the law school, is actually married to Leslie Kendrick, the dean of the law school, and Scott Ballinger, also an alum of the law school, and runs our appellate litigation clinic. So I want to talk about the clinic. I've done an episode before on clinics. It was a while ago now, and it was with a student who was in the Innocence Project clinic. So we talked a lot about that. I'm really curious because the Supreme Court litigation clinic seems to me like it's very prestigious, it's maybe competitive. Tell listeners, how does one get into the clinic to begin with?
So the clinic is open to 3Ls, third-year law students, and in their summer between their second and third year, they'll send in an application. The application's not super sort of involved. Right now I ask for a cover letter, a resume, and a transcript, and a writing sample. And then I have a co-director of the clinic, Bob Long, who works at a law firm, Covington and Burling. Mm-hmm. And usually Bob and I will see the applications come in, we'll talk through and say, like, how do we, we have an incredibly qualified group of applicants. How do we sort of narrow this down and to a dozen students? And that's a really tough process. I mean, honestly, I wish we could take more students. There are a lot of amazing, amazing applicants every year. But, we want to also make sure that each of the students that's in the clinic gets sort of incredible amount of mentorship and experience and the opportunities that continue to sort of make people interested in the clinic going forward.
So how much do grades play a role?
I think they definitely play a role. I won't sugarcoat it. And I think the reason that they play a role, like, for instance, we have a case right now that we're working on about sort of venue and sort of which is sort of where a lawsuit gets filed. And that has to do with civil procedure,
Yep.
which is one of the core first-year law classes. And it's not a big deal for me that you get an A or an A plus or an A minus in civil procedure. I think it's more to say, look, like all the questions that we're trying to answer, they're not necessarily answered in the casebook. I mean, that's why they're going in front of the Supreme Court. And so why grades matter is I think there's a signal to say, I've read the decision below, I've read some of the cases. Am I going to be committed to sort of take a deeper look, to go that extra step of the way in my research and in my sort of thinking about this in order to come up with an innovative or novel line of thought. Now, of course, like that's not the only way you can show that. You can also demonstrate it through work experience and other sort of items in your resume. So certainly grades are not dispositive. I think it's just one way to signal.
Right. I mean, hey, I do admissions. I get it. It's really tough. Yeah. Sometimes, like, it is going to be things like that like help you decide, when you have so many wonderful people. I know it's difficult. So it's a year-long clinic.
Yes.
Are there any prerequisites? Like, do they have to have taken Fed courts or something?
I don't think there are any prerequisites. Okay. I think unlike some of the other clinics at UVA, like, say, the immigration clinic or some of these other sort of specialty clinics, like for us, our case matter is really varied. So sometimes we'll be working on sort of a securities class action. Sometimes we'll do a criminal case. Sometimes we'll do a case about employment law. And, so there, to me, it actually is really great to have students that sort of have a variety of different interests. Like if I had 12 students that were only interested in constitutional law, it would be really tough sometimes maybe with the securities law case. Right.
So. That makes sense. So I'm curious, what is the breakdown between like what are you doing when the class meets versus what are they then doing on their own the rest of the time?
Yeah. So I think our big class meeting is a way to sort of convene for like this overall team huddle for all 12 students. And I think that's important because sometimes we'll have what are known as case rounds where the smaller, usually for the 12 students, we usually break them up into 3 or 4 teams of 3 or 4 students. And so, on a weekly basis, maybe those 3 or 4 students will do a presentation to the whole class about their case, a case round. And I've actually found that to be really incredibly helpful because I think between myself and the 3 students that are dedicated to a case, that's all we think about. But then when you have someone else who's really, really bright and hasn't really thought about the case that much, but sort of has these other background concepts or experiences, they can really provide a lot of insight. I mean, in both of our cases that were argued for the Supreme Court this year, we had sort of arguments that we made that just came out of a case round, right?
Wow.
Like a student was like, well, I haven't really thought about this, but what about this idea? And I was like, honestly, brilliant.
Wow,
and so we'll do that, and I think that's a good way for the whole class to feel invested in everyone's work, work. We'll also try to do speakers during the case round, so people learn a little bit more about how the Supreme Court and appellate advocacy works. Sometimes we'll do moot courts, and so that's sort of. But it's not necessarily supposed to be this intensive class session. I think the sort of the bulk of the work, the bulk of what happens is these sort of individual case team meetings that happen on a weekly basis or more frequently, depending on how busy a case is.
Yeah.
And that's when I meet with the 3 or 4 students, sometimes in my office, sometimes in a small conference room. And we start talking about what they found on the research, what they, how to craft an argument, how to recraft an argument.
Yeah.
And so that's pretty intense, I would say. And yeah, it definitely is more work than the 80 minutes that is blocked out on the schedule.
Yeah, because they're participating in writing briefs, right?
Yeah.
And obviously, yes, like you said, coming up with arguments and things like that. So, and research.
Yeah. I mean, and just on like each one of those takes a ton of time. I mean, especially from the Supreme Court. I mean, last year we had one brief. I was looking this up the other day. I always sort of save sort of new versions or different versions of briefs as like version 1, version 2, version 3. And I think on one of our briefs, it was like, I think we were at like version 47.
Oh
and then we just renamed it. So it's definitely more than version 47. But, we really, really try to make things as perfect as we can be in front of the Supreme Court. And so, and I think, I think the learning that takes place happens between version 1 and 47, right? And I think that's how you become a better writer, a better thinker. And it takes a ton of work. There's really no shortcut there.
Yeah. It's September, which means a lot of you may already be hard at work on your law school applications. But I also realize that a lot of Admissible listeners out there are folks who are much earlier on in the process. You may be wondering, is law school even right for me? What's it all about? And what do lawyers do anyway? If you're thinking about applying to law school but don't really know where to begin, be sure to check out Season 3, Episode 1 of the show. UVA Law professor Joe Ford joined me to discuss all the things you should be thinking about when it comes to this rather big life decision. For someone out there who's listening to this episode, maybe it's the beginning of their college career, maybe they haven't even gone to college yet, but let's pretend they're in a relatively early stage of thinking about law school. Do you have advice in terms of what they should study in undergrad, what kind of internships, like what kind of advice would you give to a person who's maybe just embarking on their college career?
I don't think there is really a particularly like one track to prepare you. I think, stereotypically a lot of people would say, well, I'm going to major in history, or maybe I should take some Latin or whatever, I should take English if I want to write a lot. I'd actually say, no, take all different things.
Right.
Because what I think students should do is study what you're interested in, study what you're passionate about, study broadly. At this point, I'm closing in on 1,000 or so students that I've taught in my courses. And I've had students that run the gamut for majors, right? I've had everybody from your stereotypical history, English, business person to people that were computer programmers and engineers, and they've all been super successful. There's not one recipe. Don't try to fit yourself to the mold of, quote, a lawyer. Bring yourself to that role.
Okay, this is to me the most fascinating part of the clinic. How is it even guaranteed that you're going to have a case, right? Why don't we start with the Ames case?
Sure. Yeah.
So for people who don't know, can you just give a brief background of like what the case is, what are the issues, how it got to the Supreme Court?
Yeah, so the case is a case involving Title VII, which is Title VII of the Civil Rights Act, which is a part of the Civil Rights Act that essentially seeks to root out discrimination in the workplace. There are other titles that seek to address discrimination in other forms, but Title VII is the one that seeks to root it out at the workplace. And the Ames case was a Title VII case where this individual alleged that she was subject to discrimination on the basis of her sexual orientation. So she brought her case first in federal trial court. She didn't get very far. She lost. She appealed it to the Sixth Circuit, and the Sixth Circuit sort of also dismissed her claim. And that's sort of where we came in, and we called and said, hey, we think your case has some potential to go to the Supreme Court, and we'd be happy to file a cert petition for you and represent you before the Supreme Court, because that's a pretty specialized version of practice. I think when we talked about earlier, like how is trial practice different from appellate practice, we said, look, trial practice is different from appellate practice, and appellate practice is a little bit different from Supreme Court practice. So we really want to help you. We think that there's a chance that the lower courts got it wrong, and we'd like to take this up to the Supreme Court. And that is a case that, I think many other folks reached out to, and we were really lucky to be able to be selected among the many that reached out.
Are you then working alongside her counsel who represented her at the Sixth Circuit?
Totally.
Okay.
Totally.
Okay.
Yeah, I think this is an area where I think some Supreme Court specialists differ. My understanding is that there are some clinics and some law firms that say, look, you give us the case files when we go to the Supreme Court, and then like you as the trial counsel, just sit back and watch and let us work. And I really sort of disagree with that. I think that's not right, because first of all, it's their client. They've worked with them for a long time. They've built that trust. And secondly, I think that the life cycle of a case is such that the lawyers need to work together. They really need to work in partnership. And so, do we as UVA sort of do the bulk of the writing and the research and the work? Certainly at the Supreme Court stage, but at the same time, like, we always share drafts with our co-counsel. We always say, look, I'm not really sure if this is right, so let me know. And sometimes there are things that are not necessarily in the factual record, but you would really want to know and really want to get a sense of. And so for the Ames case, for instance, like, I just flew out to Akron, Ohio, and I sat down with her and her trial counsel and said, hey, let's spend a day here and let me just really understand the case. And I'm not going to be able to know everything in a day, but I'll know I'll get a better sense, and at least you'll know who I am. And then if I have other questions, it's not like I'm a blank person on voicemail. You know who I am.
Yeah.
And everything.
I mean, that's what advocacy really is all about, right?
Yeah.
Like, I'm sure she wanted to know you wanted to know her. What is it about this case you think made so many people reach out?
One of the sort of key questions that the Supreme Court usually wants to tackle is when there's something known as a circuit split, which means that the appellate courts around the country, I mentioned there are 12 appellate courts around the country, whether they come to different conclusions on the same sort of legal question. And there was a circuit split here, and sort of everyone acknowledged that there was a circuit split. And so that sort of suggested that the Supreme Court wanted to, might be interested in taking up this case. So that's, I think, part of why other people wanted to reach out. I think certainly there's discussion about the case in terms of sort of its like socio-cultural, political ramifications that made people want to reach out. I think most of the times when we reach out and offer our assistance, there are other people that have also reached out and offered assistance, not just in Ames, but in almost all of our cases.
And is that pretty common of how you get a case, of how the clinic gets a case? You're reaching out to somebody at that level?
Yeah, I mean, it depends. It depends. I mean, I think the best model, and probably the model that would allow me to have more hobbies and sleep more and be a better tennis player is if folks just came to us.
Sure.
and they are coming to us more. I will say they are coming to us more. One of our cases last year, someone just came to us and said, I heard you'd done really great work and would be super privileged and excited to work with you.
That's cool.
The other, and I think the more grueling way, is you get up really early in the morning and you read these opinions and you're like, all right, I think there's a circuit split here. I think I'm going to try to reach out, and here's how I would pitch UVA, and here's how I would sort of say that we can offer an advantage, and here's sort of the questions that I would have for the local counsel, and here's how the conversation I think should go. And, it's similar to sort of the CV resume comment that I said earlier. I mean, I think it's easy to say, look, hey, the UVA's landed some great things, but we've also lost a few of them, and it sucks to lose. But I think that's sort of a learning experience that you just go through that, look, I can do the best and try to pitch us as well as I can. And sometimes people will end up going for, another law firm or another law clinic.
Well, I was going to say, it's pretty remarkable if you think about it, that the client would choose a clinic of law students versus like a Williams and Connolly or a Covington, right?
Yeah, I think.
Or are they? So then this didn't even occur to me until right now.
Yeah.
Is this like pro bono?
So two things. Like, one is, yes, like we offer our services, free of charge, right?
Yeah.
The
students aren't making aren't billing hours for this.
You could see the car that I drove in on. It was not a Lamborghini. So we offer our services free of charge, but a lot of law firms do too. And I think
because of the prestige.
Yeah.
Okay.
Because of the prestige, because of sort of the marketing value, the experience that it affords. First of all, I certainly lead with and talk about sort of how remarkable our students are. And that's because of your work, honestly. You find really great folks. And so I just coast on your laurels now. I say it's not just the students. It's certainly not just me. I mean, we have an incredible faculty here, right? And an incredible librarian staff and an incredible sort of set of staff and researchers. And that's something that a lot of other places don't have. And so I've been on pitch meetings where I say, look, the lower court that decided your case also, in deciding your case, cited an article by Aditya Bamsai. Guess where he works? He works four doors down from me, and I can just call him.
He's a law professor here. Cool.
And so I think that provides us sort of a comparative advantage, but it's an incredibly competitive market.
So competitive. Any case that goes before the Supreme Court, I imagine, there's going to be some like venue issues. I know that maybe are not that controversial, but like this one I know had some like controversy surrounding it. And so, first of all, how do you talk students through that? I'm just curious because I'll just reiterate for listeners, like this was a reverse discrimination issue. Basically, a straight cisgender white woman saying, if I'm discriminated against, in other words, she was not promoted in favor of an LGBTQ plus person who was promoted and then she was demoted. Basically, my understanding is, okay, well, if you are claiming reverse discrimination, you actually have a higher burden to meet than if the reverse fact pattern was true. And so you could see that like would push some people's buttons.
Yeah, totally.
So what conversations happen like either within the clinic or like do you hear from people even outside of the clinic? How does that work?
Yeah, well, certainly I hear from people outside of the clinic, for sure. I think, it's sort of incredibly tough to land one of these cases, but it's also incredibly tough to advocate and figure out what the strategy is and to sort of hear all the noise from outside. That can be really distracting, and it can be really tough at times. I'm definitely not going to sort of sugarcoat it. And to your point, it's not sort of relegated to just sort of this sort of more high-profile case. In our other case that we argued had to do with retirement benefits, and a few of my friends who work in finance who aren't in law would call me and be like, I can't believe you're doing this. This is going to ruin my relationship with my clients and everything. And
meanwhile, I'm thinking that's pretty dry.
I know.
Yeah.
And so whenever it gets to the Supreme Court, like there's going to be some level of controversy, whether it's the broader public or it's a smaller section of people that are really invested or interested in the issue. And I think what I try to tell our students is like, we're not going to be, our clinic will never be like Michael Avenatti. We're not going to be like out in the press trying to sort of advocate our case. I think what we want to do is we want to work with our clients. We want to come up with the best legal strategy. And we want to put that forward and base that based on research, precedent, fact, text, and see where we go. And I think we have a good track record there. And I'm really proud of that track record. But I think with our students, to me, I've tried to sort of emphasize that when it gets sort of tough and when there's, I certainly don't want them to feel sort of any opprobrium or anything like that. But I think I try to sort of flip it around and say, look, this is a really good learning experience. It really is a way to, because, when you're in a big law firm, often you're going to take positions that are unpopular and may in fact be wrong. Like, who knows, right? And I think figuring out and navigating like, hey, what's real out there and what's the law say and how do we sort of advocate for this fairly and with integrity? Those are really key questions that we want students to really develop and learn and think about as they navigate through law school.
It's like what moot court is all about or what mock trial is all about, right? Like you're arguing for a position that you don't necessarily agree with. Like when I was in big law, one of our biggest clients was like Philip Morris.
Right.
Do I agree with anything that Philip Morris does? Like not necessarily, but you see how arguments get made. You see the creativity of arguments like for a client like that. And I think that's all toward the good for, developing young lawyers. I also tell students like the Supreme Court kind of is what it is right now. So, like, any chance you have to see how they rule, this is going to be probably the makeup of the court for many, many years to come. And so for our students who are graduating and practicing, like, this is going to be sort of where we're at. I'm curious, actually, now that we're talking about that, do you talk to them about the Supreme Court itself? Like, in this day of 2025, they are under scrutiny. Are they really independent? What's going on with the Trump administration? Like, how much does that come into play or not really?
Yeah. Well, I want to hop back really quick. I think this will tie back into your question. One thing that I think did make a difference, and it is something really, really critical for me as a professor, especially that I want to bring to my students, is to really get a sense to know our clients. So I made sure they all got to know Marlene Ames, because it's really, really easy to make generalizations and come up with sort of narratives or stories or stereotypes or whatever. But look, if you meet her, I mean, such a sweet woman, and to get a chance to meet her and talk to her and see like, hey, this is a woman that went from, working her decades at a social services agency, ending up sort of well-reviewed, well-regarded, ended up sort of pulling herself up to sort of have make about $100,000 a year, and was a single mom supporting 2 kids, and to lose that and to sort of have her salary cut in half for something that she really doesn't know why she got. I think that sort of puts a human face to things, and it becomes a lot harder to say, well, we should be up here, when really sort of what's going on is working with an individual and trying to get them to sort of have the courthouse doors open for them. So I think that really matters. I think sort of your broader question about sort of the Supreme Court, to me, I think working with the students on the cases and seeing how we were able to craft arguments that sort of had support from all sides really actually, I hope, gave them some faith in the system to say like, hey, there's at the end, you really want to come up with arguments that appeal to everybody and to sort of really sound and work for everyone. But there's no question that there's sort of a broader discussion about the Supreme Court's role and the makeup of the court and sort of how it plays within our society today. And I certainly don't shut the door to those discussions. I mean, in the last couple of years, I've had Bertrand Ross, who used to be part of our faculty, come in. He was part of President Biden's commission to look at the Supreme Court. And I've had him come in and talk about sort of the broader structural place of the Supreme Court. And we do have those discussions for sure. And I think those discussions enrich the experience. That said, like, there are, I think, so many classes at UVA that have those discussions. I think our thought is, we're working there in front of them. How do we do the best and get justice for our clients?
Yeah, I think both are important, right? Like we're working, totally. like I said, this is what we have.
Right, exactly.
We're not changing the Supreme Court anytime soon. We're working with what we have, but also I think, to Bertrand's point, like we can also think critically about where this is going and all that. So Ames was your second time arguing before the Supreme Court. Walk me through, like, the clinic is mooting you, my guess. Totally. Okay. And so how long are you preparing before this?
We were so busy. Once a case is granted, you'll file what's known as your opening merits brief. The other side files their response brief, and you file a reply brief. And, our cases were sort of back-to-back months. And so our reply brief, I argued in front of the Supreme Court, I think, January 22nd. That was my first argument, January 22nd of this year.
And that was the Cunningham, like, retirement benefits case.
Yeah. And my birthday was 2 days later. And so I took, I guess, 2 or 3 days off for my birthday. And then, so that's sort of late January. And then by February 7th, we had to file our reply brief in Ames. And when you're filing your reply brief, you're not thinking about oral argument. You're just trying to get the reply. This is the last written word you get in front of the court. So that's February 7th. And I think the argument was February 24th or 26th. So it's like 2.5 weeks. And basically those 2.5 weeks, I think I did 3 or 4 moots at different places. But yeah, I remember we sent in our reply brief. I think I took a nap, and then the next day, I mean, this is the great thing. Usually my first moot is with our students, and it is always hilariously bad. And honestly, like, I think it would, like, not get past, like, the quarterfinals of the Lyle Moot Court competition. It's so bad. I think for my first sort of moot in Cunningham, I'll be honest, I think some of the students had some questions. But then my last moot is also with the students, and I think they can sort of see. And I think that's helpful because, I think in the end, when you see it, you're like, wow, they were able to answer the questions. They were cool under fire, and, they had a ready answer. And, it's not like that. Like, it's sort of this random set of pieces at the start, and you see it coming together over, moot 1, 2, 3, 4, and it ends in a good place. But to see it build, I think that's a good learning opportunity for the students.
So you basically had your first ever Supreme Court argument and your second ever Supreme Court argument like a month apart.
Yeah.
We're kind of flip-flopping now between Cunningham and Ames, but I think that's okay.
Yeah.
What was your first argument like? Like, were you terrified?
I felt pretty prepped. I don't know if I was terrified as much as, there's a certain amount of pomp and circumstance that goes with arguing for the Supreme Court. And that's really interesting and really fun. I mean, you get to be in the stage and you get to sort of be in the lawyer's lounge beforehand and prep your notes. And, the person that I was arguing against, my opposing counsel, had argued 33 times or something beforehand. So,
wow.
And so I think that I wouldn't say I was terrified. It was just sort of like taking the court for the first time and trying to understand what it was like. I will say we were the second argument that day, and the first argument was about this like police shooting, Fourth Amendment question. And when you're the second argument, you sit behind the first argument. And you sit behind the first argument, and the Supreme Court is like, I don't know, like 30 feet high. Like it's this cavernous, majestic building, courtroom. And where you sit, if you're the second argument, is like right under the lights, and it's like a heat lamp. So like, I remember going to the bathroom a couple of times just because like you would be sort of, you're like baking, you're like sort of baked
God.
Alaska out there, and then like you're trying to drink some water, and then you're like, I need to get to the bathroom, and they're like, I hope they don't call my case. So, and so I think that actually sort of takes some pressure off, because instead of like thinking about like, what am I going to say, you're like, I honestly need to just have like an empty bladder and like a like a not sore throat when I get up there.
Yeah.
So.
And so that case was a 9-0?
Yes, yeah.
Congratulations.
Oh, thank you.
That's incredible.
Oh, thanks.
And Ames was also 9-0.
Oh, yep. Thank you.
I mean, so this is why now you don't have to go out and find cases anymore.
I definitely still do. I wish I didn't, but yeah, it's always great to see that.
That's
for the clients. But yeah, there's still hard work to be done. Don't worry about that.
I have no doubt. Did these clinic students just get like extremely lucky to have two cases kind of going on at the same time, or is that normal?
I don't know if they would say they were extremely lucky. I think in retrospect they would, but during the time when we were working on it, I mean, I think we put in a lot of hours and a lot of time, and the students were remarkable. This isn't just all we were doing. We had some other cases we were working on, and they put in like really, really fantastic work. They hold like a really special place in my heart for all the work. But really all my students, because I tell them, and when I say that they've done such great work, it was actually they worked on the merits cases, but the last year, the students before that worked on the cert petition. So it's like I've really been blessed with sort of multiple classes of incredibly hardworking and incredibly intelligent students. I think they were very fortunate this year. They got to go to the Supreme Court several times to watch the argument, to see how the justices react. They got to go. The Biden and Trump administration supported us in both cases. And when that happens, you actually sort of work as a tag team with the Solicitor General's office, which is sort of the office within the Justice Department that argues Supreme Court cases. And so we'll go up there and we'll just sit around a table with members of the Solicitor General's office and think about strategy, think about argument. And that's an opportunity that I almost never got in the law firm.
I was going to say, that's very rare, right? I mean, and they're getting that. That's awesome.
We got to moot at what's known as Georgetown Supreme Court Institute and got to see sort of Georgetown faculty ask us tough questions in both of our cases. And so I think that they had an incredible amount of opportunities. I'm really glad we were able to give it to them. And I think in exchange, they all sort of put in a lot of time. And very, very grateful for that.
That makes me so happy. Makes me so proud of them. Do you know what this upcoming year, what cases you're working on?
I do.
If you can't share, that's okay.
No. I can share a little bit about it. I think, we've had a case that's been pending, which is this Fourth Amendment case about dog sniffs. And basically there's sort of an open question in the lower courts that if you get stopped and a dog goes around and sniffs your car, if they just go around and sniff your car and they don't touch your car, that's actually constitutional. The Supreme Court has already decided that question. But there's an open question of like what happens if the dog walks around and say, like, you have your window open, they just jump through your window, and then, like, they jump through their window because they think they smell drugs or whatever. You know, is sort of jumping through a window, is that considered a trespass? And if that's a trespass, is that a Fourth Amendment violation? So we represent an individual out of Iowa. Her name's Ashley Mumford. And we are arguing that that is considered a Fourth Amendment search. And so right now that's in the very final stages of briefing. I actually need to finish writing the reply brief by next Tuesday. So
oh my goodness,
4 days from now.
So you're, just so I understand, you're arguing that that is a lawful...
An unlawful search.
Unlawful
search,
so
yeah. And,
Fourth Amendment violation.
Yeah,
okay.
And the other side, represented by the Iowa Attorney General's office, says that that's totally fine.
And presumably, this would only come up if something was found,
right, exactly.
when the dog jumps through the window. So student listeners out there, you will learn all about this in crim law, you know, fruit of the poisonous tree and all that stuff. So, wow. Oh, I can't wait to hear how this goes.
Yeah. I think we really hope for the best for our client. I mean, I think that this is an issue that definitely comes up. I mean, the police use dogs all the time, and often they ask you to roll down your window to give your license and registration. So I think that I think it's definitely an interesting issue. We have another case that involves what's known as venue, which I mentioned earlier. It's sort of, where do you file a lawsuit? Incidentally, that case has to do with a dog bite. So we are like a sort of
the dog
canine themed clinic this year. And then finally, we're working on some other matters that have to do with environmental law, with retirement law, employee benefits law, and voting rights. So those are operating in the background.
Really cool. Do a lot of students in the clinic have aspirations to clerk or to even clerk for the Supreme Court?
Certainly. I think probably more so than sort of the general population of students at the law school. And
I imagine it helps them be competitive for a clerkship to go through the clinic.
Yeah. I mean, you know, I think it's just a conversation, and I'm sure that Scott Ballinger has the same conversation with his appellate litigation clinic. But a lot of the times, many times, judges, if you apply for a clerkship, judges will call your references or your recommenders, or they'll call me, for instance. And it's, you know, I can say really great things about all my students that I do end up saying, but it's one between saying, like, hey, this is a great student, to say, it's one thing to say that, and it's another thing to say, this is a student that worked on a merits case for the Supreme Court, and they wrote this section of the brief. I can tell you that. Their name can't be on it, but like, I can tell you that, and like, I trust them to like, and if I trust them with sort of an argument that goes for the Supreme Court, I think that that's a level of credibility and legitimacy that would be really sort of helpful for a judicial law clerk. So I think that those conversations really matter, and I think it's been really, really supportive of our students in being able to apply for and land clerkships. Yeah.
Before we wrap up, because I know you have this reply brief to work on.
It's all good. It's all good.
I really want to return to what you said about, you know, a human client.
Yeah.
Okay. Like, all these cases before the Supreme Court involve people.
Right.
Right. At the end of the day, they involve people. This venue question that might sound super boring.
Yeah.
Someone got bitten by a dog, presumably, right? Just because it's you hear Fourth Amendment or whatever amendment, it's like, this is a person or these are people. So I'm curious, now that you've argued before the Supreme Court twice and you see the judges, do you see students like feeling conflicted about clerking for certain judges? I'm asking because of how political everything is now. Everything is political.
Yeah.
But like we were talking about before, you know, this is the Supreme Court we have.
Yeah.
And you have made two arguments that all 9 agree.
Yeah.
So in theory, we can agree on things, right?
Yeah.
So I just feel that this is so important to talk about today. Like, how would you talk to a student or counsel a student who maybe is someone who could clerk on the Supreme Court but feels like conflicted because of their own like personal values?
Well, first I'd say, you know, apply and hopefully be in our clinic, because I think every year that I've taught, including the time when I taught in Northwestern, but certainly at UVA, we've had students of all political persuasions, backgrounds, racial, gender, religious backgrounds. And that is a real strength of UVA, and really thanks to the admissions committee for finding those folks, because what it means is that when we can talk about these issues, and we can't talk about it just in the abstract. We have to represent our client, and we can say, all right, I know you guys come from different backgrounds, you have different views, but how do we come up with something that would make sense, that you could understand, that you could agree with, because that's going to be what's going to work with the Supreme Court. And I think that is something that I really value and treasure. I think for the students, though, I would also say, look, you learn a ton from clerking and from working and from seeing how sort of the law is formed and established, and how to be a great advocate. And you'll use those skills, and sort of, there are definitely going to be times where you work for a judge or where you work for a law firm that you may not agree with everything. And, that's okay. Like, people don't agree with a lot of things. And that's okay. I think what is something that you can sort of take from it is, like, what can I learn? How can I be a better advocate? How can I sort of work with my clients? How can I come up with sort of what I hope are arguments that folks can really agree with from across the aisle? And if that works, I think then I'm doing my job.
Yeah.
And I would really sort of counsel students to say, certainly there's a degree of politics, there's a degree of partisanship and polarization in society at large, and in the legal system perhaps as well. But you can either add to it, or you can try to work through it and maybe sort of turn down the temperature a bit. And I have always sort of mentioned to my students that I really want to be a person that turns down the temperature and sort of thinks about how we can really advocate for our clients and come up with things that are workable for everyone.
Yeah, I love that. You can add to the polarization, you can do what you're doing, which is turn down the temperature, or you can sit out entirely, which is almost like the worst option. So like getting in there, understanding how it works, the difficulty of crafting an argument that will get that 9-0, ruling. I mean, I think that's what it's all about.
I mean, I think it's totally right. And I think that one thing with Ames in particular, I remember, is one of the professors, I'm not going to name names, one professor, a couple of professors actually told me, they were like, well, if you just change this argument and sort of really like play it into like a grievance narrative or whatever, like you could just win it 6-3, and like you could be like it could be a lot easier for you. And I just looked at them and I said, like, yeah, we're not going to do that. We're definitely not going to do that, because I don't think that gets us anywhere. And I think that it's certainly probably harder to come up with sort of universal arguments, to come up with sort of the research and to listen through to the precedents and the text and to really investigate the history behind certain clauses and how to interpret them. But I think what comes out is a better product for everyone that we can agree with. And that takes work for me. It takes a ton of work for me. It takes a ton of work for my staff. It takes a ton of work for our students. But I think that's sort of what we want to teach our students at the end of the day. And I am really fortunate for the law school's support for that, behind that.
Yeah, that resonates with what I tell our students all the time. I mean, it is going to be hard work. Trying to do it the easy way, or trying to do, that's never going to get us where we want to be.
Right,
I mean, we're UVA Law. Why should we be trying to take the easy route?
Well, when you said something about sort of, you could sort of turn up the temperature or turn it down or sort of sit on the sidelines, I think that, and I don't want listeners to take this the wrong way, but I think that if you're a UVA Law student, I really don't think you can or should sit on the sidelines.
Yeah.
Like you have already proven that you're incredibly gifted and talented, sharp and precocious, and you have this privilege to be able to really help people and to sort of work in a legal system and improve that legal system. And I think sitting out on that is something that society loses out on, but you definitely lose out on.
For sure, yeah. I tell them, remember why you applied to law school in the first place. Sitting out is, I agree, completely not an option. And I have been honestly so inspired by this conversation. It makes me so happy that you're here. It makes me so proud of all of the students. I'm going to go back and look up who was in the clinic each year, because it makes me so excited for our 3Ls who are about to have this experience. Yeah. So before we go, because most listeners are thinking about applying to law school or they're getting ready like to apply to law school, what advice would you give based on sort of everything we've talked about, your own experience?
Yeah, when it comes to applying to law school, I think that, in some ways, as you craft your application, some things are set, like your LSAT score and your undergraduate GPA. But I think what I would say is, hey, what's not said are sort of make sure you have a great set of recommenders and references. Make sure you sort of keep up with those folks and write a personal statement that reflects who you are. And I think as things come in, have an open mind about where you want to attend and go to. I'm certain for some people, they may not think of Charlottesville, Virginia as a place that they could imagine themselves, but then they come here and they fall in love with this place. Yeah. So I would just say have an open mind, and if UVA is something that you're interested in, my email is on the website. I'm happy to talk and be a booster for this place.
That's so nice. And as we've talked about, in the middle of everything you're working on, that's very generous. So thank you. This was awesome.
Oh, thank you. No,
this was
I appreciate it. This was great.
So fun.
Yeah.
Thank you so much for taking the time. I know you have just so much going on. You just got married.
Thank you. Yes.
Congratulations.
Thank you.
Glad you're back from all your travels.
Yes.
And I'm excited to see what you guys do this year.
Yeah. Same. Hopefully we'll be able to give some great opportunities again for our students.
This has been Admissible with me, Dean Natalie Blazer at the University of Virginia School of Law. My guest today was UVA Law Supreme Court Litigation Clinic Director Xiao Wang. For more information about UVA Law, please visit law.virginia.edu. The next episode of Admissible will be out soon. In the meantime, you can follow the show on Instagram at Admissible Podcast. Thanks so much for listening, and please remember to rate the show wherever you listen to podcasts.